Hey everybody, I hope you and your loved ones are safe, happy, and healthy. Before you listen to or watch the show, remember to subscribe and follow us on Twitter, Facebook, and LinkedIn to stay up to date with all the latest news and updates from my legal club. If you, your family, or your business need any legal support or no obligation solicitor quotes, please get in touch with us at mylegalclub.co.uk. Before you listen to the show, please note the content is for information purposes only and is not to be relied upon. Stay well, and I hope you enjoy the show. Welcome to the MLC show. I am your host, Sean Rogers, and I'm delighted to be joined on today's show by Scott Birchall, Director at Smooth Commercial Law. We're going to be discussing in today's show examples of when pension advice goes wrong, including defined benefit pensions and investment failures relating to self-invested personal pensions, or SIPPs, as they're more commonly known. Scott has extensive experience in property and banking litigation, as well as large value, complex contractual disputes. The cases Scott has been involved in vary from your standard landlord and tenant dispute to multi-million-pound banking disputes. Scott and his team have helped clients secure redress in highly complex claims, often relating to pensions and failed investment scandals. And I am proud to call Scott a friend as well. So Scott, how are you, mate?
Very well, thank you. It was a beautiful introduction. I appreciate that.
Glad that we've made you blush. Before we get stuck into the show, what's the best thing about being a solicitor and running your own business, and what's the hardest aspect of that?
It has to be the variation. As a commercial litigator, one of the things I enjoyed right at the outset was simply the variety of work. One day I could be dealing with a complex banking dispute. The next day I could be dealing with a property matter, or financial misselling case. As they say, the variety is the spice of life, and I think it does ring true for commercial litigation.
And getting stuck into pensions, why do you think we've seen a big rise in pension misselling and claims relating to pensions in the past decade?
One word: opportunity. I think that when the rules were laxed in terms of what individuals can do in terms of their pension, it meant that there was an opportunity there for missell. I'm not saying that everyone who has lost money because of a pension issue has been the advisor or the SIPP company set out to take money off these individuals. But I think it meant that there was an opportunity in the market for those individuals who, let's just say, are somewhat unscrupulous to take advantage of individuals' pensions, and they were able to orchestrate a scheme there whereby they were able to get money from what would be safe and secure pension into a SIPP, and then onwards into a unregulated, unsuitable investment.
And you're just touching on it there, but could you expand on what is a SIPP and why would someone transfer into one?
A SIPP it's a wrapper. It's a tax wrapper. It's a conduit through which individuals have a greater flexibility into what they can put their pension into. SIPPs aren't all bad. SIPPs are very useful, and a lot of advisors recommend SIPPs for tax benefits. But in my view, they should only be really used where, for instance, we have, let's say, business owner wants to buy a property from which they can then occupy for the purpose of their business. So they buy the property in their personal capacity, transfer it into the SIPP, or the SIPP purchase the property, and then the business rents it from the SIPP. But what it shouldn't be used for is what we deal with on a daily basis, the schemes which are unsuitable, the offshore property schemes, the plantations in Bolivia, the storage units, the off plan, German property companies. Those are the sort of things that SIPPs really shouldn't be used for, or certainly shouldn't be used for Joe Blogs. They really should only be used for those individuals that have a clear understanding of what they're getting themselves into.
And talking about investments, when investments relating to a SIPP fail to perform or even collapse completely, the harm caused can be absolutely devastating. Can you give us some examples of investments, in the press, investments that have failed? What was the idea of the investment and what went wrong?
Yeah, I mean, just to hammer home the point that you made at the start, the damage is absolutely catastrophic. We're talking about people's pensions, that their savings that they've worked extremely hard to save up, that they put into a pension on a monthly, yearly basis in order to give them some sort of life after they retire. This money could be earmarked for children, grandchildren, for retirement plans, and if these individuals are now faced with a situation where that money has gone, the results can be catastrophic. We've had instances where individuals have had to find part-time jobs, in order to kind of build up the pot. If they've already retired, have individuals that are having to go back to work. It's devastating for these people. It really is. We do take great satisfaction in being able to help these clients get their money back. The gratitude and the thanks that we get is startling, more so than any other cases we deal with, and it just shows the impact that these cases do have on individuals. The types of schemes that we're involved with really does vary. We've dealt an awful lot with storage units in the UK. These are these warehouses that you'll see, which are split into individual units and then rented out to individuals to store their items. The companies that set these storage companies up, what they did is in order to gain finance, investment for the development of these storage units, they were often advertised to investors, and the investors invested into the storage units, acquired a storage unit in essence, and then they were rented out back to end customers. So that's one particular scheme that we've been heavily involved with. More recently, we've been involved with a offshore property-based company in Germany, whereby clients have invested into loan notes. So they've acquired a loan note. In essence, it's a piece of paper that says, you lend me £1,000 at a certain date in the future, we'll repay you X. The loan notes were supposed to be secured against property in Germany, never were. And lo and behold, the scheme, the German property company has recently been placed into administration, but the properties weren't built. So the money that was invested into this company in order to develop all this land in Germany for supposed tax benefits never came to fruition. And then now clients are left with nothing more than a piece of paper that says, I owe you X pounds, but if the company behind that piece of paper has gone under, then the clients are stuck. And
financial losses, being incurred from a SIPP, that doesn't mean automatic redress, of course. Some of the examples you've given there, you can see where the loss has been suffered, but what would constitute that being missold? What would give you rise to make a claim?
So there's various claims that we look at. So the first claim that we look at is the financial advisor. So if the clients were advised by a financial advisor to transfer out of a pension into a SIPP, then there potentially is a claim there for misselling. The actual act of transferring out of one's pension into a SIPP has to be it has to be advised upon, because it is a serious step. Clients are transferring out of a pension which may have certain defined benefits attached to it. So the clients are foregoing those defined benefits if they transfer out of the pension into a SIPP. So if the clients weren't properly advised, or if that wasn't suitable for the clients, then there's potential misselling there. If the advisor has also advised the clients to invest onwards into an investment scheme that wasn't suitable, high risk, unregulated, then again, there's potentially a claim there for missell. When I say missell, what I'm really talking about here is negligence. The advisor was negligent in providing the advice, A, to transfer out of the SIPP in the first place, and B, onwards into the unsuitable investment scheme.
Yeah, it's an interesting backstory to that. I remember the days when off-plan foreign property developers, probably around 2007, like pre-crash, in and around that time, were looking at the English economy and seeing that a lot of people had equity in the houses. And I think from the naughty property developers and developers abroad, they saw the view that they could potentially take advantage of potentially legit IFAs and circumstances in the UK, where they would move people from a capital and interest repayment mortgage, remortgage to the hilt, put them on interest only, raise a load of capital to invest, no repayment vehicle on the interest only mortgage now. So you'd move people who a lot of equity in the house, paying the mortgage off, going to own that asset outright when they retire, if you will. And then they've managed to funnel these funds overseas, probably with the best intentions. But the property developers then run off with the money, property is then not built. And then that gave rise to FSCS claims and then subsequent judicial reviews. I suspect, and just debating it, I suspect that what's happened is because of the credit crunch and the issues that then surrounded interest-only mortgages. And I certainly wouldn't applaud this because of what's happened, but I think some of the more iffy developers overseas have gone, well, if we can't do interest-only mortgages, is there anything else we could go for? It's like, well, yeah, because of the crash, recession, pensions aren't performing, and therefore we might have a mechanism where we can say to people, your pension's underperforming, why don't you move it? We'll take advantage of SIPPs and that path of using a legitimate source in the right way, and we'll take advantage of that and then get our hands on the capital within that SIPP for these off-plan foreign property. And even if they have the best intentions to go off and do that and build them properties or whatever the project may have been, when they don't happen, you then got a massive problem on your hands. So, you know, it's great that you're being able to assist clients, but I think for those who may not know, I believe that's the kind of path and journey that's gone from interest-only mortgages and led to SIPPs in essence of getting their hands on that investment money.
I completely agree with you. I think it is, again, it's the point I made earlier, it's the opportunity. As if you've dealt with cases as long as I have, you can see there is there's kind of a journey. So you start off with certain advisors and certain SIPP companies at the outset, so 2007, 2008. And yes, you are right. The interest-only loans, clients were told to, sorry, you start with the properties, and individuals were told to remortgage their properties to release equity. Then it transferred over to the SIPPs, and you see that there was certain regulated financial advisors that were advising at the outset, and certain SIPP companies that were accepting those sorts of clients and those sorts of investments in, say, 2008, 2009. And then as you go over time, you can see that the usual suspects, as it were, the advisors, the SIPP companies change, because you see what that particular SIPP company in 2009, 2010 may become, under scrutiny by the FCA, or may realise that they potentially got an issue. We're no longer taking the work. So these advisors then found another SIPP company that would take the work. So yeah, again, opportunity. These advisors saw an opportunity and were able to monetize it. That being said, I do agree with you as well. That's not to say every advisor was negligent or every scheme was set to fail. Far from it. I've come across advisors that, they feel so bad that they are in essence falling on their own sword, and they've approached me on behalf of their clients and said, look, Scott, I know you deal with this particular area. I'd like you to help my clients, even if that means that they come after me, but I just want to put them somewhere safe and secure. So, advisors, certain advisors have realized what they did was potentially wrong, but they didn't set out to do it in the first place. Equally, certain investments that I'm aware of, they certainly weren't set up to fail. there were a number of years of successful trading before, for whatever reason, they could no longer carry on, and clients lost money. That's fair enough, but that does not alter the fundamentals, which is these investments should only have been recommended to certain individuals, certain high net worth, sophisticated individuals. These schemes should not have been recommended to Joe Bloggs on the street. These are very highly complex schemes that you should only have been recommended to invest in if they were fully aware of the risks that were involved and they accepted those risks.
And a SIPP's covered by the FSCS, and secondly, what does the claim journey look like with the FSCS files in the courts? Are they paying out on missold SIPPs, pension losses?
Yeah, there's been some recent important case law. There's the case involving Barclay Burke, and the recent case involving Carey's pensions, now options, that do give us an indication of how the courts will treat these cases. The ultimate problem is that once a case is brought successfully, inevitably the SIPP company, well, Barclay Burke certainly has. I know there was with Liberty SIPP as well. They fold. Options, Carey pensions haven't yet. There has been the recent successful Court of Appeal case. I understand that options are, sorry, when I say options, I mean Carey's, but there is talks that they are, well, I know that they've applied for permission to appeal that decision to the Supreme Court. So I'll wait to see what happens there. But yeah, the courts are taking a very pro investor view. So the courts is one route, the Financial Ombudsman Service is another, and the Financial Services Compensation Scheme is another. Ultimately, it depends upon the client's circumstances, how much they've invested, the value of their claim, and whether we have a viable defendant to pursue. The beauty of these cases is, well, for some clients, the beauty of these cases is that there is always the Financial Services Compensation Scheme, which is, as I describe, it's a safety net. But it's certainly not the only route for remedy. Every client should first consider whether they would be better suited opting for court or the Financial Ombudsman Service first before they consider the FSCS. If the FSCS is a scheme of last resort, so it's only available if the SIPP company or the financial advisor is defunct. Damages are capped. So when we start with any case, we will consider all the circumstances, see if we need to put it to the Financial Ombudsman Service or whether we opt for court proceedings. If the only route available for them is the FSCS, we will pursue it for the client via the FSCS. But like I say, it is only a scheme of last resort, so we would have to explore for options first.
And on the subject of defined benefit pensions, I've seen that people have had to seek redress for defined benefit pension transfers. Could you touch on what a defined benefit pension, if I can get my words out, what a defined benefit pension is and what might it have been transferred into? People might know that their family or friends may have been in that situation.
Well, defined benefit pension schemes are normally attached to occupational pension schemes, whereby individuals, it says what it does on the tin, receive certain defined benefits via their pension. So over a period of time, they will have guaranteed returns. They will have a good indication as to what they can expect to receive, or will know the formulaic arithmetic as to how that will be calculated at a point in the future. There are certain excellent pension schemes, defined benefit schemes, armed services, police, teacher pensions. I came across a Rolls-Royce pension the other day, which was unbelievable. I mean, the returns that this gentleman would have expected had he kept his pension where it was astronomical. But unfortunately, he was advised to transfer out and into a SIPP. So a lot of the clients that I deal with, they have been transferred out into a SIPP. There are other conduits that they could have transferred out into, but the SIPP ones are the ones that we normally deal with. I think one of the things that I always drill into my team, it's not necessarily the investment itself that's the missell. It's the step before, it's the advice to transfer out of the defined benefit scheme into a SIPP. It's the loss that the client suffers because they transferred out of the defined benefit scheme into the SIPP. So this gentleman, the Rolls-Royce pension that I mentioned earlier, even if he hadn't have invested into whatever he invested into, he still lost money because he had transferred it out of his pension scheme, his defined benefit scheme, into the SIPP. So he'd automatically lost because he did that. Now, in my view, that's where that is where the missell starts. A lot of people get, hooked up on the actual end investment scheme, the storage units, the plantations, this. It's not, it's the step before, it's the actual advice to transfer out of the pension, which is key.
And just to rattle through a few quick examples of, final salary pension schemes, defined benefit pensions, you've got things like Armed Forces pensions, British Steel pension scheme, BP, BT, Jaguar Land Rover, Marks and Spencer's, teachers' pension, etc. And I was reading recently that the Financial Ombudsman Service has received 44% more complaints in 2020, sadly, than it had the year before. And the FCA were looking at this, saying that they believe 50% of the pension transfer cases they were looking at back in 2018 were unsuitable. So if you do know anyone who's had a defined benefit pension, based on those figures, it would be well worth looking at the advice they received and how that's gone on to perform. If someone was looking at how to potentially make a claim for missold pension or pension losses, Scott, how would they go about that?
There's one or two ways they can deal with it. They can do it themselves. The Financial Ombudsman Service is a free service. They certainly are free to make their complaint to the Financial Ombudsman Service. There's certain rules that they need to comply with first, and there's certain time limits to that. If the advisor or the SIPP company is now defunct, they could obviously look at the FSCS. That again is subject to certain time limits and also caps on level of compensation. Alternatively, they can instruct the solicitor. The solicitor will take responsibility for the case and advise the clients on not just the procedural issues, but also the legal and regulatory framework that they are applying under. So, for instance, a certain recent case law on claims against SIPP companies, which I think is very important. So anyone making a claim against a SIPP company will have to be fully aware of that. If the client would prefer to go to court, I would certainly recommend speaking to a solicitor rather than dealing with it as a litigant in person. Court cases can be quite complex, and again, there are a lot of procedural and time limits that they need to comply with. So yeah, those are two options really: deal with themselves or speak to a solicitor.
And does everyone appear to be on the same page? Obviously, the Financial Ombudsman Service, FSCS, the courts, you'd like to think they would all follow the same sort of logic and precedent, if you will, but they're not necessarily bound to do that. Yeah. Are you finding that as far as FSCS and the courts are sort of taking the same approach to these things, or are you finding any differences?
I think there's certainly differences between them. They are aligning more than they ever have been. The biggest difference was the Ombudsman's approach in relation to claims against SIPP operators and the court's approach. Obviously, with the recent Court of Appeal case, that is now aligning, but the decision, the kind of the basis for the decision and the ultimate findings are somewhat different. So it's not one shoe fits all, and that is also a reason why you would want to consider at the outset what is best for the client. Is it the certainly the pro-investor approach down the ombudsman? Is it the court route, which there is still up in the air, involving there's certain cases which leave matters somewhat up in the air. The FSCS are really they are obviously it's a government body, and there's individuals within that kind of interpret things slightly different from other individuals within the FSCS. So it's to a degree potluck as to who you get. But I have to say that the Financial Ombudsman Service and the Financial Services Compensation Scheme are simply inundated with cases at the moment, and it must be very, very difficult for them to cope with the level of claims. So yes, there are quite extensive delays at the moment with both the Financial Ombudsman Service and the FSCS, but they're certainly working through the cases, and they're doing their very best.
Are there any specific deadlines that apply that people would need to be aware of where a claim may be time barred, and what they can do to avoid the claim being time barred, where in essence they lose on a technicality because they brought the claim too late?
Yeah, so for the courts, it depends on the actual claim that we're bringing. But if it's a claim for breach of contract, then it'll be 6 years. So we advise all clients to bring a claim within 6 years of the initial advice, if it's against a professional, if it's against a financial advisor, or 6 years of when the SIPP was set up, if it's a claim against a SIPP. Now, in professional negligence claims, there's a secondary period, limitation date, strictly for only negligence claims, whereby 3 years, the client has a kind of a 3-year window after which starting from the date when they should have been aware they had a claim, that they have to issue court proceedings. In my experience, a lot of the investments that we dealt with failed more than 3 years ago. So that secondary limitation can be up as well. So a lot of the early investments, 2008, 2009, may already be statute barred. The Financial Ombudsman Service, again, there is time periods involved in that. There is an initial period of 6 months from the date when the claim. So you would, if you were bringing in a financial ombudsman claim, you would send a letter before claim to the advisor or the SIPP company. When they provide you your final response, you'd have 6 months from that date to submit to the Financial Ombudsman Service, and then a long stop date of 6 years from the date of advice as well, that you would need to bring a claim. Strictly speaking, the FSCS is bound by similar time periods, but in my experience, they actually don't really apply them. And if you have got a claim, we've had claims over 6 years that we've submitted to the FSCS, and they have accepted. So strictly speaking, they should do, but I know that they don't apply those same time periods.
We'll whisper that gently. I'm glad that the FSCS are looking after consumers that have suffered in this way, and wouldn't lose out on a technicality. In essence,
I should strongly put though that these time limits are very, very stringently ruled, in the sense that they would give an absolute defense. We've had cases that have been rejected because it's outside of time. So anyone who wants to bring a claim, we would strongly advise that they do so within 6 years of the advice. And if they can't, if they haven't, to do so, act as quickly as possible, whether they opt to bring it themselves or whether they want to instruct solicitors.
Yeah, it's important we read out the FCA disclaimer, if you like, that in any area of financial misselling, you're able to claim without any fee being charged against the regulated party directly, and if necessary, via the appropriate ombudsman or statutory compensation scheme, which could be the Financial Ombudsman Service, the Pension Ombudsman, and the Financial Services Compensation Scheme, better known as the FSCS. And there's no reason why you would achieve a different or better result by instructing a solicitor or claims management company. Moving on. Are there any other areas of financial misselling, Scott, where you're being asked to help people and advise concerned clients at the moment?
Yeah, at the moment we've got an awful lot of CFD claims, contract for differences, that we're currently involved with. Somewhat similar in the sense that these involve a form of mis-sell, where clients have been advised to invest into a contract for differences, high risk investments portfolio that have suffered loss because of it. Again, that's something that we feel quite strongly about. Clients have lost an awful lot of money. We feel there's there's certainly redress there available to them. I also deal with a number of banking disputes, claims against banks for a whole host of different reasons. And then also undisclosed commissions, where clients have paid unknowingly commissions, or brokers have received commissions for a whole host of different products, such as subprime lending, mortgages, energy contracts, internet contracts, that sort of thing. So we're dealing with an awful lot of those as well at the moment.
And if someone's concerned in financial misselling, some of the areas we've discussed, and they're looking at maybe instructing yourself or going further forwards with it, what should they do primarily? What do they do in terms of documents, evidence? Should they make a complaint to the individual directly first? What would you recommend that people do if they're in a situation where they're concerned enough to maybe start making the complaint?
I think it's very important that you speak to a solicitor first. What you wouldn't want to do is make a complaint half-cocked at the outset. It's best always speak to a solicitor if you feel that you have a claim. Speak to a solicitor, even if it's to get some initial advice, and then your intention is to proceed on your own. At least a solicitor will be able to set out any sort of, like, say, time issues, procedural issues that you need to deal with that you might not otherwise be aware of. Make sure evidence is king. Make sure you have all of your evidence, all your documentation that you may possibly have in relation to the scheme or the investment or whatever financial product. That could be emails, correspondence from the advisor. It could be application forms, any sort of documentation like that. Make sure you've got all that together. Don't bury your head in the sand. Really, if you have lost money because of negligent advice or some form of missell, then act as soon as you possibly can, simply because, again, if you fall foul of any sort of limitation date, you could potentially, even if you have the best case in the world, you could potentially lose the opportunity. So I think it's vitally important to act quickly so that you don't lose the chance of bringing a claim.
Well, thank you so much, Scott. You've been a fantastic guest. Thank you so much.
Well, welcome.
That's it for this week, everyone. You can find out more information about how to contact Scott and Smooth Commercial Law in the links to this show. Please share and spread the word about the MLC show. If you listen on Apple Podcasts, please hit us up with a 5-star review. And remember to check out the products and services at mylegalclub.co.uk. But more importantly, please stay well and take care.